All right.
Just when we start, you'll need to
He's
move.
that guy. Jesus.
It's not getting a bash. I did slam it into the wall.
All right, we're gonna go ahead and call this into session. So we are here for a criminal case brought by Sparks and Jang over there, related to one Frodo Dachi, represented by Mr. Paul Hammerstein. Now there was some commotion on the docket having to do with a motion that was granted, and whether or not that motion and the items were granted during discovery was fulfilled or not, and some back and forth. I'm going to make this real simple. I do not care about the color commentary and the flourishes that people may have added to their communications and or actions and or lack thereof. More just interested in what happened, what didn't happen, etc. So prosecution, you made the motion, so let's start with that. What was the issue with the motion that I granted in the delivery of those documents during discovery?
Our biggest thing is, Your Honor, with all due respect to the court, our biggest concern was any consideration for any future roads violations and spark notes concerning the lack of information we received from one department. The San Andreas State Marshals received compliance from the Los Santos Police Department and the Blaine County Sheriff's Office as it pertains to either records or lack thereof concerning this matter. We did not receive essentially receive fervent denial of any cooperation from the Ocean Drive Police Department. As long as the court understands that we made our best attempts to coordinate and receive information from all departments, there's no further issue concerning that motion on the motion to compel to produce documents.
Okay. There still remains the matter of my motion being granted, my directive being ignored and refused. So let's move to that. Paul, do you have any knowledge of this, or were you involved in that? No.
Wait, what?
For as far as the request for the ODP reports, is that
yes
the primary part there?
I
guess I was.
wait.
Curious
Female, white long hair, black top,
based on
black plaid shirt, threw a knife into a courtroom.
So that would be my extent as far as the scope and the breadth of what they would be trying to establish here in this court, there, Your Honor. But
so why wasn't an objection made on the docket? Why was there just an outright refusal to comply?
Oh well, I guess you had established that we were going to be doing a bunch of pre-motion trials here, and so that's why I thought I was going to be bringing that up here. So I apologize if that was not the candor or
regardless, right? If there's something during discovery, it needs to be turned over per my order. And then if it is not relevant, or you believe that, you know, there isn't anything probative to be found in the documents that were provided, then you can object to them being used as evidence, right?
All right, thank you.
Yeah, correct, Your Honor. I guess I was just going from your instruction there that we will be doing all these as far as the pretrial motion. I didn't want to sully up the jock.
And the communication regarding the outright refusal, that came from you or from a representative of the ODP?
I haven't refused anything, Your Honor.
Okay.
I don't refuse much.
Who did that refusal come from, Sparks?
That would come from the Assistant Chief of Police of the Ocean Drive Police Department, Haley Maxwell, Your Honor.
Maxwell in the room?
Yeah, right here, Your Honor.
So what's the deal with that? You can approach. Jesus. Have a sidebar about this.
Yes, sir.
What the fuck? Someone apparently threw a knife through security. According to Barrett, he said he would.
Yeah, that's normal for you.
It is, yeah.
Yeah.
Yeah, and I patch definitely does inhibit.
Maybe got too much sand in your eyes, you know.
I have a
need to come down
singular
to the
eye.
city.
What do you expect from me, guys?
Yeah, exactly.
I am not transferring to LSPD, Mona.
You can do it.
Radio check.
It's not too late.
So, lady, apparently the lady with the white hair black plaid bottom, black shirt, threw a knife past security, and then picked it up. She's gonna be in the front row.
Hello.
Should probably notify the judge about it.
Hey, firm, I'll pull on the side here as soon as the sidebar is complete.
I just want to double check description. You said female, white hair, eye patch, black outfit.
Eye patch wasn't confirmed, but that matches the rest of the description. She's got everything else.
Cameron Rose, I'll talk to him.
I'm just keeping.
You're lesser of a person.
Apparently, a couple people have been throwing knives over, so the entire side over there might be fucking armed. Yeah. Someone needs to pull Craig Barrett aside and get a more accurate statement from him.
Hi, Froda. It's me, Hazel.
Hey, Hazel, come up here. I have a spot for you.
Wait, really?
Yeah.
Let's go, Belle.
Come on, Belle. You too.
Can I have you step out here in the hallway with me for a moment, please? She got a question for you.
Thank you, guys.
One eye.
You got a little bit of a.
Well, if I go through there, it's gonna take.
Talk.
Hey, that's her. I saw her do it.
Did the suspect leave?
Possibly, and there apparently could be a couple of them.
All
But like I
right.
said, someone needs to
Trowel out of the
contact
way,
her.
some discovery stuff.
Contact
Yeah,
Barrett.
Pocket.
Fun fact, Ray.
They gotta make
She
it
was
about them.
notified the day of and has reviewed the docket.
One
about 45
moment.
times
Hi,
today
V.
since then, according to the views on the docket. So she's already
Sorry,
aware
I
of
have
that.
to.
The docket snitches on people who views the
Oh,
docket. I don't know if anyone else knows that.
Oh yeah, I just looked through it, and I think they've read it more than I have. Yo, there ain't no way they might got. Man, I wish I knew what the hell was going on with them, but damn. Oh shit.
And then she decided she wanted to dress me down and call us disgusting and stupid and all charges were irrelevant and she didn't know anything about charges.
Yeah,
Crane's been made aware. He's about to speak on the podium about it, I believe.
All right, ladies and gentlemen, make this real fucking simple, okay? At this point, I have received credible information that people have smuggled contraband in the courtroom, including weapons. I don't look favorably upon this because I have no desire to have this court case maligned by violence. So, therefore, here's the deal. If you are in here legally as a member of law enforcement, this does not apply to you. If you are a judge, this does not apply to you. To everyone else, in about 30 seconds, I'm going to give a directive that law enforcement should pat down everyone in this room. If you do not
Motherfuckers
wish
ain't
to be
touching me.
patted down, you can leave.
Oh my gosh.
Bubba, I know you planted that.
I'm scared.
So in the end, I'm gonna use my extended magazines. Okay.
Okay, nobody
Pat
being
this
patted
down.
Your Honor, there's nothing to pat down. It's flat.
What the?
Understood.
You disgusting.
Motherfucker's that scared?
PD, you may go ahead and delegate who you need to go ahead and pat down the room and ensure there are no weapons in the crowd. Knight, if you want to organize that, thank you.
Yeah, sure. Voss?
Okay, perfect. We're going to take 2 minutes for this to happen because I'm not proceeding with a court case where I'm not convinced
All
that
right.
there are not multiple weapons in my court.
Everybody else that uses the sector wants to pat down. You have the.
Do you mind if we have people go out and then come in after patted in?
Yeah, that'd be fine. You can run them through the metal detector and going out and in.
All right, guys, here's what we're going to do. Everyone's going to go through the metal detector. Let's go.
Fuck that shit.
Okay.
Hey. Thank you so much.
All right.
If you don't want to go through the metal sector, you'll be detained.
Yep.
Okay, but I already did. So
All right, come on, let's go. You heard the judge. Come on.
God damn. Yeah,
Every single person through the metal detector. Let's go.
Scared in this bitch.
Jump set.
the middle
Yep.
I just got
Everybody
patted
was in the
down.
metal detector.
Come on, man.
You're good to stay. She just went
Yeah,
through
I
the
just got.
detector. I
She
went
went through it?
Already
Okay, beautiful.
How are you
getting stuck?
Left side
Because
is good.
Bobby-
No. She's going through it again.
File,
No,
come
she's
on,
going
guys.
through it again.
This.
Come on, Blood.
Single file.
Every single individual. Let's go.
Have everybody go through one more time. I know you just
I'll
did,
check
but
if she's on
I like
the
the-
All right.
No exceptions.
Not yet. Everybody, everyone through. Come on, come with me. Everybody past the
Everyone
middle
single file.
detector.
Everyone
Come
from
on.
this side, single file, please, if you don't mind.
I went through. Did you see?
No, I want everyone's gonna
You're
stay
good.
there, and then we're all gonna come back at
Oh,
once. All right.
okay, sorry.
Damn.
All right.
I appreciate your cooperation. We want to have people on shifts manning it from here on out.
Yeah, having one person's fine.
Hi, Cece.
All right. All right, fantastic. Barrett, can you go through there as well,
step
please?
through the metal detector.
Barrett, you as well, please.
One as well, have them removed.
Awesome,
Okay,
thank you.
one of y'all run security on me because they know I've been
Thank you,
snitching
Wayne.
on them and I'm gonna get fucking stabbed.
Thank you, Pockets.
All right, Barrett, you too. Come on.
Thank you, Jesse.
Be nearby.
Can
All right.
watch me
Frankie.
so I don't get stabbed?
Thank you, Hazel.
Yes, I'm watching you, Craig.
Thank you.
shot.
Thank you, Hazel.
Fucking
Oh,
wish.
and then like the whole court case.
Thank you, Belle.
All right, fantastic.
Thank you so much for everyone's compliance. We appreciate your patience.
Thank
For safety for everyone.
you. Thank you. Good to see y'all. Thank you.
Did you think you was?
Oh.
Let's go, Rusty.
Yep. Trying to look along.
Do you want to search me too? I don't mind.
You're good. You're good.
Okay.
Move along. Move along.
Pocket.
I'm gonna step back.
Can I slip out real quick?
Hiya.
Yeah.
I'm gonna pop out.
Yeah, Leviticus.
And I'm coming back in.
Thank you. Keep it going, guys. Keep it going. Every single one of you. Every single one of you.
I could take your camera. I could take your camera.
All right.
What was that? Oh, you said, good to see you too. I'm sorry, I'm just overwhelmed by all of the people here. It's a lot of people.
You okay?
All eyes on me.
All right.
I'll hold you up.
Oh my god.
Can I place it on the ground?
Y'all want to stay here just until most of the crowd comes through?
Oh, I will keep staying here and I will fucking snitch.
Yeah.
I will snitch on anybody trying to smuggle shit into this courtroom. It's fucking sacred in here.
I know that's right.
Come on, old man.
It's a lot of people.
Who was it?
But that's
All right. Thank you for that night. Appreciate you.
Yeah, absolutely.
Okay, we're gonna go ahead and get things going then. We will start with opening statements. Let me just make this formal. So this is gonna be criminal 80 on the docket. People v. Frodo Dachi.
Pockets don't do it.
Yeah.
Can I hit the gavel to start the court proceedings?
Yeah, but not yet. I'll tell you when.
Kick him out.
Okay. So it's gonna be people v. Frodo Dachi.
You laying in the middle of the road.
There is allegations from the prosecution that Mr. Dachi is allegedly guilty of corruption, evidence tampering, felony obstruction of justice, and obstruction of government or public computer systems. Paul, is your client giving a mixed plea or a blanket one?
Well, it smells like you've already thrown the shit around in here.
I believe. Actually, let me confirm there just to double check. There you are.
All right.
Hello.
I'll blanket, Your Honor.
Okay. How does your client plead to those 4 charges? Corruption, evidence tampering, felony obstruction, and obstruction of government or public computer systems.
Not guilty, Your Honor.
Understood, Mr. Dachi. Thank you. Court recognizes a plea of not guilty has been entered for all charges. All right. Prosecution, you may begin with your opening statements at will. Thank you. You can go ahead now, Pockets.
Your Honor, just a quick motion there. I thought we had pretrial motions set there regarding the striking of evidence there. Was that not to be addressed
Yeah,
before?
we can do that. Hold on. Sorry, Pockets. Yeah, that's perfect. Thank you. I forgot there may have been outstanding motions. My fault. 1 second.
Yeah, it's all good, Your Honor.
I know the relevance of the particular portions of the evidence that you use.
Who is that?
In an effort to avoid me having to dredge through the docket system, Paul, why don't you just go ahead and make any motion you have to make?
Oh yeah, sure. I guess I
or
can just go through it.
prosecution, whoever has open motion.
People do not have any opening motions at this time, Your Honor.
Thank you, Sparks.
I guess just to go further with it there, for our motions there, for first of all, for motion to strike on Slew People 16, the phone subpoena of Lucy Fur, dated from April 2nd to 7th. There's no signed affirmation to consent, as required insertion seizure legislation, section E2. And he recorded so-called consent from the interview provided, was dealt with what we believe as a defense to be coercion when Officer Fur was asked to consent by Sergeant Gray, where her response was not in the affirmative and was followed by Officer Gray's use of hierarchy of the LSPD as her superior, along with Marshals Wayne and Director Knight present to coerce a haphazard agreement. That's the main gist of that one, Your Honor.
All right, Sparks, do you have any rebuttal?
Coerce?
Wayne knows more about that particular piece of evidence, so I'd like to concede to his information. if that's okay, Your Honor.
Yeah, Your Honor, first and foremost, the thing he's suggesting right now with the search and seizure legislation, that's for search warrants, but not only that too, the particular part that he's saying is required, the key word is should be obtained, not that it's a requirement. Big thing here right here is that specific piece he's quoting is dealing with search warrants and not subpoenas. At the end of the day, what he's alleging is that unless a signed verbal consent does not exist in this state. First and foremost, we have on recording Lucy Fur, who identified herself, and also under Miranda, and also she consented. That's well documented. Her consent is the signature on the recording. Anything beyond that, or any sort of nitpicking, or trying to do a little gotcha, is frankly a waste of time. And yeah, as far as any sort of coercion, there's no proven coercion or anything like that. We literally gave her multiple opportunities to say no. She could have recanted, her consent at any point, and she didn't. Any sort of, insinuation there was coercion by some sort of hierarchy or having a marshal around any form of coercion is not only ridiculous, kind of asinine to be honest, but unfounded.
Here?
Oh, I'm here.
Okay, why don't you approach, ma'am?
Oh, okay. Hello.
Hey, why don't you come over here to the witness stand real quick? Square in real quick.
Oh, shit.
Go ahead and have a seat. Raise your left arm up to the sky when you're ready.
Oh, shit.
You swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth, under the pains and penalties of perjury, so help you God.
This is a trap from Crane Watch.
So sworn in, Your Honor.
All right, Ms. Fur, this is gonna be pretty simple. This is not going to directly, conclude the matter, but I am loath to hear two people argue as to someone's state of mind when I have them in the room able to testify if they so wish. So this is voluntary. I'm not forcing you to testify.
Yo, I hope she lies
I'd like to clear this up, and I'd like you to
God.
restrict yourself if you so wish. So keeping all that in mind, keeping the fact that you're under oath,
because he's gonna listen to the tape afterwards.
You gave affirmative consent for that subpoena, and/or vis-a-vis, were you coerced?
Well, I was a little worried that I would get fired if I didn't cooperate, so I just said yes.
Okay. Understood. Thank you, ma'am. We appreciate you. You can return to the gallery.
We buzz out. You go next.
Your Honor, do I have a chance to rebut to Marshal Wang's response there?
You can make a final commentary, Paul.
Okay. No, it's not gonna be long. Just because it's the point where he's claiming that this is just about search warrants. Yet under section Article 1, Section A1, clearly defines search warrants. Refer to
exactly what document you're talking about, Paul.
Search and seizure legislation, Your Honor.
Okay.
Article 1, Section A1, search warrants refer to a search and seizure warrant, but then also includes subpoena of phone records and other records, search of electronic devices or notebooks, personal effects, and investigative warrants. So the fact that Marshal Wayne is saying that a search warrant does not cover subpoena is factually inaccurate.
Okay, and and the language that was being discussed about it being signed in writing, what are you citing to?
That is Well, let me just make sure I get this right. I think it's A3 of Article 1. I may oh no, sorry. Wait. It is, I had it a moment ago here, Your Honor. My apologies.
The thing is, that's only for Section A.
Sorry, I know I have it written and highlighted here somewhere. Section E. Sorry, yes. So search and seizure legislation, Article 1, Section E, number 2. A citizen may provide permission to law enforcement to search their property without a signed search warrant, provided this is documented. I believe that also then relates to as far as a search warrant. For them, and that search warrant extends to that Section A1.
No, it doesn't.
Okay. And that's the remainder of your commentary on the matter, Paul.
Yeah.
Okay. I'm going to take a second, have a teaching moment, discuss this with some of the other judges. I'll be right back.
File not found.
So technically speaking,
Oh, well, I mean,
what
we're
we're doing is subpoenaing information. Crane should know that. So that being said, a search warrant is for real property. Real property is like physical property.
I didn't know I was gonna get called up
has
there.
nothing to
I
do with
wasn't ready for
subpoena
that.
because it does go over the specific language of a
Yeah, that section has nothing to do with subpoenas.
and blah 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 blah. So there's no reason that this should the legislative intent of this particular portion specifically is for the consent for a real property search warrant rather than a subpoena for information because we're not searching the phone. We're subpoenaing the phone company for information.
Subpoena notebooks.
As you are.
Correct.
Another example.
Right, Wade?
Correct. You search a physical property. You subpoena information.
I'm forcing him to be your family.
I said that in my comment as well about production and whatnot.
Well, he said thank you. That's it. And
the whole case is gonna be like this, Wayne. I need you to
Hey,
look the fuck
is that Bubba over there
So
in the leather
your
jacket?
Funny little haha TMZ moment has been on instant sale when they decided they wanted to take recordings.
Yeah, it is. That is Bubba.
Man, that
Right
motherfucker was saying
beside-
hella shit. I didn't even know.
Yeah.
Yeah, it was him. He said, "Yeah, they must be scared." That's Bubba. That's the one.
That the legislative intent.
Why I have extended magazine for that.
I know
We're
you told me.
subpoena of phone and bank records and other records, not a search and seizure. We weren't searching the phone.
Brian,
We were
I'm
subpoenaing
shooting
for
straight to all of these people. Okay, to the
So-
target.
because this
Wait, now I understand looking at the left why someone had a rat up their ass. Oh, now it makes sense.
Depending on what he does, this is
I mean,
essentially the case.
just walk through the metal detector. They better bring us some food or some shit.
Oh my god.
That's it. Listen, I'll give you some advice. It's a little. That's a trick question. Don't answer that. I've been done by that one before.
Oh.
When they start asking questions like that.
Dun dun dun.
And asked Mr. Little, who hasn't spoken to her in like 20 days, if she thinks he's stupid. Other way, he thinks she's stupid.
Hey.
Hey.
I heard what happened. I'm sorry to hear.
Yeah.
I'd love to learn more.
Regarding the motion to strike
Whenever you get a chance.
for the contents of the subpoena for Officer Lucy Fur. First, I'll start with the coercion aspect because that would blow everything else out of the water, regardless of the.
Oh, he left.
So coercion is a very
Fine,
thing in
that.
terms of the law.
What's going on?
How y'all doing?
I was looking for our one friend was supposed to be out here.
Oh, gotcha. Ma'am, if you bring a knife in again, it's gonna end badly.
I didn't bring a knife in.
Look at me. Do you think I'm stupid?
Someone must have planted it on me because I didn't bring a knife in.
All right.
I don't even
Let's
use
not
knives.
have it. Let's not have that happen. All right.
Okay.
This is exactly why we,
Better
have
watch
things
somebody.
like Brady warnings and, a whole different set of standards in terms of their documentation, FOIAs, right? They are treated very differently when it comes to those things. If this was a a witness who was being coerced under like threat of violence, extortion, etc. I understand those things. However, being worried that you might lose your job, to quote Ms. Fur, while that is, I would say, personally, I believe that that would be not a great workplace environment. But that's a personal opinion, and I don't believe legally it amounts to coercion, as you would rightfully, I think, understand that in situations like police corruption cases, etc., there would be an expectation that you would comply with investigations, much like the idea within Brady about giving statements. That being said, this is not a very, I think, precise, clear-cut issue. Although I am going to rule there was no coercion to make this inaccessible. As far as the second prong that Mr. Hammerstein spoke about with the legislation, after reviewing the legislation, I believe the following. I believe that Paul is ultimately correct in that, yes, that legislation does relate search warrants to include subpoenas within the language.
But the section
as a
doesn't.
broad, encompassing statement in the beginning. That being said,
Only in section A.
If you read the exact site that you cited, Paul, regarding
It's regarding
that was
properties.
E2, where it states the signature should be signed and dated. The key thing for me there is that it specifically references a search of their property. Now, there can be arguments made that searching phone records is a quasi-sense someone's property.
But it belongs to the
but
phone
I
company.
think that's too tenuous an argument, and I don't buy it. I think the clear context clues in that E2 there guide the reader to understand that when they are referring to property and they're referring to physically signed search warrants, they're referring to search warrants in their specificity. So while I do agree with Paul's point overall for the guiding context of the overall document, I think that point itself is very clear. Therefore, I will be admitting the subpoena from Miss Fur. Any other motions, Paul?
I guess, yeah, secondly, the other one was also in regards to a striking of evidence. This was for striking People's 10 for the further stolen subpoena. Now, obviously, I guess supposed to be you guys had there the first part, you're not striking this, but I do believe this is separate, in fact, for a couple of reasons. The one that I stated there before there was the second consent contract, that within that subpoena, they then have included what looks like a contract where they are trying to show that there is a signed and dated consent. However, there's no actual showing of any sort of page that does show any signed consent. Furthermore, with respect to some of the evidence that's been presented, namely from evidence.
Hold on. So is this one motion or is it multiple?
No, this is just one.
Okay, go ahead.
So yeah, so this is striking. The report that's striking is 45155 People's 10, and further from let's see here, which one was it from? Ties to another piece of evidence, Your Honor, that I believe is very important to understand. As far as an order of which they collected their evidence. Apologies. Oh, here we go. From evidence report 45240, there's a mention of them collecting a photo that was captured on April the 7th. This happens to be the date that looks like they actually requested, and I actually can't see when their subpoena was actually signed off on, so I'm just wanting to ensure when exactly they did in fact capture this photo of evidence based on that prior subpoena.
He thinks the evidence was added later.
Okay, so you're trying to strike item 10 from the people, which is 45155, and then 45. What was the number on the second one?
45240 just kind of illustrates that for the fact
Where
that
is that? Because that's not showing up in the reports for me.
45240 should be the second report.
No, I'm saying like I'm just looking at the MDT.
Oh, it doesn't show up there at all. Like if you're on the docket, there's for the list of reports. Like the very first report they have
Yeah,
there was the.
I can do it from the docket.
Yeah.
Okay.
I think I'm saying the number right.
Why were these motions
So,
not filed?
and your objection to 45240 is what? This photo from the 7th, you said?
Yeah. So there's April 1st. They're showing a photo from Lucy's messages captured 4/7/26, which, based on the collection of information here, I'm just trying to establish when that photo was in fact taken. Because if that was taken on the 7th, and then they established that they were trying to get another subpoena. Well, it appears to be late on the 7th. I want to know when they got that actually signed off there, because it is of the defense's mind that they collected this evidence outside the scope of their original subpoena request, as their original request was from April 2nd to 7th.
Okay. Well, let's start with Sparks or Wayne, whoever is handling this. Respond to the first part regarding 45155, the documentation, the signature issue.
I'm so lost. I don't even know what the fuck he just said.
I think
It's a
they're saying that
4155.
one of the photos
45155
was taken potentially.
Paul is alleging
before
that
we had,
the document
a
that
legal
is
signature on, like, they're saying that maybe we
supposedly
went out of the
supposed to be
scope
backing
from
that
the
up
original subpoena,
is
that's
not
what they're saying.
signed for
You took a
consent.
photo of 5 days when you only asked for 3, is what it sounds like, and he wants to establish when we took that photo.
Hold on a
pretty sure
second
he's
here.
grasping at
So he's not a 45155. It's not about a consent. We have an entire statement of probable cause listed in there.
What they're trying to do
Oh.
is exclude the spheres, but it doesn't
Yeah,
matter
as it may,
because
Your
the
Honor, I'm just
spheres
going
are
with
also
the
in
further
Omar's
onto this
subpoena
though.
and
Of
Hammer's.
the evidence piece there
Mm.
is that 389
So
864
it's not gonna make a
second
difference.
consent contract,
in the fucking newspaper,
which is initialed by what appears to be V. Gray, and just going further into that of this contract being essentially shown here as consent contract listed there, but it is other defense's mind that this is painting a inaccurate picture as to their
I have
further
no
probable
idea what the
cause on this
fuck
matter,
they're
Your
saying.
Honor.
Where is
Uh,
this
by
photo?
them
Do you know
including that-
which report?
They didn't show the signature page on it.
it's
They
the
just show
second
that
report
they
listed on the
have a
docket,
contract there,
Victor.
and I feel that is just trying to hoodwink and veil over the eyes of the courts there, Your Honor. And I know that justice is blind already, but they're extra blind when they're putting double blindfolds on.
Let's cut down the frills a bit, Paul. I'm fucking old, all right? So your argument is that they that this should not have been granted and they pulled the wool over the eyes of the signing judge?
Yes, Your Honor.
Okay. Say that next time, Paul.
Your Honor, may I clarify something?
Yeah.
Our statement of probable cause never used that contract as any part of evidence. There's an entirely probable cause built from the ground up in that statement of probable cause. If it's been read and reviewed, they'd see that it was signed under the merit of the probable cause, not some contract.
Commentary on that, Paul?
Well, I can't even see the signature of it, Your Honor, so I can't even know when exactly this was signed off on to begin with. So that's another part there. But that's just me nitpicking on
The
a
judge
finite
signed
scene
this
structure
on the
there.
7th of April.
Yeah, there's an entire subpoena for this.
Okay.
Yeah, but he can't see.
So they did sign it on 7th there. Okay, fair enough.
You know, it's entered in evidence.
Okay.
It is.
Paul, I'll put it this way.
Mm.
I am not equipped to sit here and teleport my consciousness into the mind of the judge that signed this subpoena to understand if it was granted based on the utilization.
No, they
of
can,
that,
though.
consent contract that you believe is incomplete
that
and or
information, he should have
misleading.
called the judges.
I am going to say that by default, my supposition should be that Justice Danielson is able to properly review a subpoena on its merits. And if he did, you believe that he made a mistake and he granted this subpoena based on being misled about a consent contract versus the statement of probable cause, then that is something that I believe you will need to challenge separately, as is your right to challenge subpoenas and search warrants. That is not something that I'm going to strike because I can't. You're asking me to assume that there was, well, not misconduct, but that there was negligence. So that's going to be a no from me on that one. Anything else, Paul?
Oh, it is in here. It's 45155.
Here, I think there might be a couple things here.
And what's the deal with
Yeah,
this?
it's right
Let's talk
here.
about this photo thing then. Wayne or Sparks, there seems to be some question about when these records were pulled and when the first was included, etc. You respond to
that? Sorry, can you repeat the question?
Which photo, Your Honor? Which, like,
So
specifically, which one?
Paul is referring to is in shared report 45240, which says Spheregate modified evidence. There is a section designated April under phone subpoena, missing photo evidence plus selective restoration. And it states April 1st, the first entry says Lucy's messages with Frodo captured 4726. That is from April 1st. Paul is questioning when those records were pulled and analyzed, because the original subpoena related from the 2nd to the 7th, not including the 1st. Because it says captured 4-7. So if it was captured on 4-7, see what I'm saying? That's his objection.
Those are in respect of PST, Your Honor. Those are just what I have on my timestamps, but those were all documented in reference to what we saw in the first subpoenas.
Fuck off, bro.
I believe.
So the pictures, okay.
So the timeline that was put in there, those are specific dates the photos or the messages were sent. I'm giving a
Hey, don't.
timeline in that piece of evidence that.
Yeah, what's up? Why are you in my face right now?
What we found
Oh,
from
you
the
can go
text
around.
from March 9th. And here's a timeline of
what
what's
he's
I didn't want to have to.
arguing is
What
that
are you doing?
if the subpoena originally said that you get everything from April 2nd to April 7th,
I'm not putting my hands up.
and then
Hands up.
on April
I have a
7th,
new
presumably when the first subpoena was issued, you access things from April 1st, then that would be outside the scope of the subpoena and improper. You understand? Because if you captured it on the 7th, and that's when the first subpoena was issued, and the first subpoena was only from the 2nd to the 7th, then how are there things from first being labeled as being captured on the 7th?
I believe that would just be an issue of timestamps, Your Honor. What's been put in UTC versus what's in PST.
What was the gap between the first and second subpoena?
4711.
Sorry, can you repeat?
Looks like, so Paul, it looks like the first and second subpoena were both signed on the 7th.
The first, when I captured the spears from the Lucy subpoena,
Were they, Your Honor? I guess again, that is information that we as a defense are not privy to see in there,
Understood.
so I wouldn't
Yeah.
be
No,
able
there's
to.
nothing improper here, Paul.
He's talking about the scope. The scope.
The second subpoena was
only from
signed on the
April 2nd.
7th, therefore
How
they
do we
were
have
within their
stuff on
rights to
April
access the
1st at
records
1
from the
p.m.?
first on the 7th. So you're
But
that's
it
going to be rejected as well.
says.
Anything else, Paul?
What are they asking? There's a subpoena right here.
There's a couple things there. Number one, I guess for my client there, actually, I guess based on his availability and things like that for this court case there, not being around. Like as far as how long this court case may be going there, we might need to schedule to split this thing, as I don't think it is fair or just in the eyes of the court for my client to not be in attendance for the remainder of his court case if he cannot attend the remainder of it here.
Wait, what?
We did actually also stipulate that multiple times there. I believe they're through the prosecution and on the docket. I just want to make sure that.
So when you state your availability on the docket, okay.
Well, you're gonna have to fucking lock it in.
I think there's probably a confusion between the availability, meaning when cases can start versus when they can end. I was under the impression that if you list your availability for court as a certain time range, that's when you were able to show up for court. If you're saying that that's the range when you can be present at all, and the top end of that range is when you must leave, then that's a different story. So in that spirit, we will see where we're at when Mr. Prodigyrp is no longer able to be here, and then we'll plan from there. Anything else, Paul?
Brother.
Are you kidding me?
What am I fucking listening to, Brian?
Remember, this is Lord of the Rings. This is part 1 of the trilogy.
Like I got a dick, you know. So can we wrap this up? Like, what am I listening to?
Hey there. Apologies there. I guess also just further adding a witnesses there for the changing of the dates for our witnesses. One of our witnesses is unavailable. We're wondering if there is a possible last-minute substitution for that there for one William Pepe to replace Gary Kevin.
He's good guy.
I'm not going to waste the court's time with too much further with that. I'm just going to put that forward there.
Kevin was already objected to, and part of this pretrial was you were supposed to justify why Kevin was relevant. So if Kevin's not here, then I think that handles that motion. We should proceed with the 2 witnesses.
All right there. Okay. Thank you, Your Honor.
All right. Any more pretrial? Anything else?
People are ready to
Just a
proceed, Your
moment.
Honor.
Okay. And Paul, by the way, if Pepe is going to be offered as a rebuttal witness, then something that comes up in the prosecution's case, then you can make that motion, you know, related to that. As we may be splitting the prosecution defense sections anyway.
Okay, Your Honor. Well, I guess just kind of sticking on the point of witnesses there, and for the fact that these interrogations that are being used as evidence there in interviews with individuals who are not being called as witnesses, feels like it's a dire and very on the point of has been the line of hearsay, Your Honor, that the fact that the prosecution has not called them to be properly sworn in on the matter, for the defense to be able to cross them on questions. Instead, we are stuck with these half depositions where only the prosecution has asked very pointed questions towards the individuals, and well, we're wishing to well, essentially put that towards the validity and the weight of that evidence, or if it should all just be stricken in that regard.
Rebuttal.
Yes, Your Honor. So first and foremost, it's standard jurisprudence and practice concerning the cut down of witnesses within the Department of Justice statewide, as it has been since the appointment of the Chief Justice. Furthermore, beyond the normal practice and standard jurisprudence, it is also up to the defense to be able to put up those arguments. If there's testimony, if there's witness, if there's information and evidence, they can wrap them up in their highlight of evidence or lack thereof in their closing and make those arguments. Lastly, they have the option to call those people as witnesses, to which they have failed to do so. They were welcome to do that on direct, to ask those pointed questions. It is not the job of the prosecution to be able to call their witnesses for them, Your Honor.
Okay, Paul, let me ask you a question. You said that you believe that these interviews, interrogations, whatever they may be, these recorded and or written statements are in effect biased and unreliable and should be considered hearsay. So am I to understand that you believe that this court should adopt the opinion that a recorded police interrogation is not valid?
Your Honor, I wouldn't necessarily go to that in this regard there. However, I do feel that it is rather an abuse of the system for the prosecution to then force the defense to call these witnesses in particular to use up all of their possible options.
You can
to defend
depose
themselves in a proper court of law. They're hamstringing them, essentially taking them out the legs, Your Honor. And I'm pretty sure the mafia really only does that. And so I'm just trying to establish if this is in fact the marshal's office, if this is some sort of other organized group.
Has he looked behind him?
Night.
I'm pretty sure that
Yeah.
it is a 2-witness limit.
purpose of
Director?
Night conscious.
Oh, yeah, I can hear you.
It doesn't matter.
Where are you from, Night?
Boston, sir.
Well, you got like 50. What part of Boston, Night?
Central Mass. Yeah.
You're not like from the North End?
Oh no, fuck no.
You're not like.
I mean,
don't own
you'd
a
be able to
place
tell
that
if I was
sells
from the North End.
slices?
Yep.
That's crazy.
Yeah.
No cousins that sell Sicilian slices night.
I'm familiar. Yeah.
Okay. Here's your answer, Paul. Not mafia.
Yeah.
Yeah, well, sure they are. I guess it is. Furthermore, I guess just I guess responding back to Sparks, I guess just notion there of the due process there. Again, I just feel like it hamstrings the defense to then be forced to call these individuals to then question them. Whereas
what,
then
Paul.
prosecution then.
Here's the deal. If we get through the prosecution's case and you believe that there are things
I thought he heard me shit
so
talking.
egregious, that the record needs to be corrected related to evidence that is pointed to and given.
I was like, how the fuck did he hear
they're
me?
sort of hamstringing you or cutting you off the legs by making you call the witnesses with your limited availability for witnesses.
Yo, I was like, how the fuck? I had to look down and be like, yo.
Calling rebuttal witnesses specifically for those topics and those topics only. Is that fair?
Sounds good, Your Honor.
Okay.
It sounds very fair and just.
Anything else? Pre-trial issues?
Yes, Your Honor. Can I have a clarification on that ruling just for the people's side?
All right, I'm just gonna make a judgment call right now. Given what I now know about Mr. Dachi's availability and given the length and breadth of these pre-trials, we're just gonna call today pre-trial day, and we're gonna schedule the main trial for a different time. We're not even gonna get through probably one prosecution witness tonight. So go ahead.
Well, Your Honor, it's just clarification. Are we allowed to have the evidentiary value of the rebuttal witnesses?
Honestly,
as
this is
per
good. There's
standard
so much shit
jurisprudence,
happening
just
this
so that
week.
we're clear on what those rebuttal witnesses would be.
Yeah.
Okay, that's all I wanted,
If
Your
he
Honor.
calls
We have
a rebuttal
nothing else.
witness and he says it's about this one specific thing, and then it meanders or it doesn't address that specific thing, then I'll strike it and I'll tell him to get off the stand.
Understood. Just clarifying. It's not a standard practice. Happy to comply. Thank you so much, Your Honor.
Okay. Paul, anything else pre-trial? Anything else we got to handle here?
No, I think everything else I can handle well and bring up in the courts here, Your Honor.
Okay. Well, here's the situation. Paul's made it very clear that there was some misunderstanding on the docket about scheduling availability, and Mr. Dachi will need to leave us in right about 1 hour. Is that clear, Mr. Dachi?
Are you fucking
Yes,
kidding
Your
me?
Honor. I could stretch like an extra 15 minutes, but then it becomes dangerous for me.
Much. So
why would you even turn up if you could only be here for 2 hours?
I don't know. That's crazy, isn't it?
What's the
Wow, let's complain about it, don't we?
Here. As far as everything in the outcomes, to reiterate, nothing has been struck.
In your case.
Paul may call
It
additional
quite literally is
rebuttal
my case,
witnesses
Buckets.
to rebut specific things that come out
Take a
in
walk.
evidence. If he so believes that those rebuttal witnesses can materially challenge the assertions made by the prosecution related to the contents of that evidence. I do not believe that there was coercion with Ms. Furr. I do not believe there's an issue statutorily with the signature notion about the subpoenas. And I believe that Justice Danielson can be trusted to sign a search warrant and review all due diligence. And if Paul feels he doesn't, then he can go ahead and bring that as a separate case to challenge that subpoena. In terms of the division of responsibilities, Sparks and Wayne and Gray are clear on that. They will handle one witness or one task at a time. You're not going to be multitasking with each other on each other's sections. And we will pick a time and date right now that works for everyone, and they can be here for the entire duration of this case. Let's estimate that this case will take, let's say, 2.5 hours at the very maximum. If it goes longer than that, I will lose my mind. So,
You know it's gonna
given
go longer
that
than that.
understanding, when is the next time that you are available, Mr. Dachi, to be here for
No
2.5
case.
hours? That starts
No court case in
after
this city.
7 p.m.
Less
Eastern.
than 5 hours.
I can make it pretty much every day, Your Honor. Saturday might be weird, but every other day I'm good.
Okay. What about Friday at let's call it 7 Eastern?
That works for me, Your Honor.
I am
don't-
unavailable.
I am
Okay.
unavailable.
Friday
Your Honor,
through
that-
Sunday.
Here we go.
What about
Here we go.
Saturday?
I'm away till Sunday, Your Honor. I'm back
You
Monday.
know, you were right,
What-
Brian. You told me this would
You're
happen.
away.
You actually
When do you
told me.
leave?
Brother, I've been to so
Friday,
many of
bright
these.
early.
I just,
Thursday?
Yeah.
I just don't know who has the
Tomorrow?
stomach to actually do this, but I guess
Thursday
I'm
works.
just an idiot.
Yeah.
No.
Wow, that's for my client.
I have a very inundated calendar. I just need to check it really quick.
Everyone check
Um,
their calendars.
What?
pushed back till next week.
After the weekend. After the weekend. After the
The current proposed time is what, tomorrow, 7 p.m. Eastern.
Like we're not doing the weekend. We have a fucking academy. Like I'm not doing this shit.
I will not be available tomorrow
311 officers,
until
marshals,
8:30.
but there's a bomb. Listen up. There's
Hello?
beeping.
Is there a bomb?
Oh boy.
Baba J has said that there's a bomb. It's a witness.
Beeping in the hallway.
Nobody move. I need a police officer. I need to speak to him outside right now.
Okay, I'm here.
Keep everybody keep everyone inside.
Okay.
Keep everyone inside for now as we try to figure it out.
Blow this motherfucker
I'm trying to move it
up if you guys
outside.
do anything funny.
Gemma, you better have a vest on.
Nobody fuck with me right now.
Brandy, don't.
Uh,
Don't fuck with me.
radio check.
Crazy.
I need you guys communicating with the.
Go down.
We have a individual with some sort of beep coming from him.
Don't want to fuck with us.
It's going to be two individuals with black and blue flame. They're being escorted out.
Hey, don't do anything
funny
stupid,
business.
guys.
You hear
Just
that fucking
one-
tick
hey,
tick?
we got
tick,
Brandy
tick.
with
This
us.
whole bitch will go kaboom.
All right, Brandy, you should stay back just a little bit, yeah?
No,
Are they in-
she's fine.
it's
She's
fine,
coming with
it's
us.
fine.
She's fine.
All right.
She's gonna be fine, Brian. She's gonna be fine.
Get your ass outside.
Yeah, but what are we doing?
For the court case?
Gotta
We'll
talk to
let
you.
you know. All right, Corny, tell him.
We should be fine. We've got them out.
What's your name?
Brandy.
76.
Brandy.
Yeah.
Back up. Back up. Back the fuck up.
I'm trying to see motherfuckers blow up.
I've always wanted the courthouse to never get bombed. That's what I've always wanted.
Inside, watch your back.
Hey, get clear the courthouse now from the back. Clear the courthouse now from the back.
Got it.
Everybody out. Clear it from the back. Clear it from the back. Just make sure there's someone there to watch.
Make sure people don't run out the front door.
She's trying to move you out from the courthouse. Don't go.
Watch your cross. Just walking the.
Hey, wait a minute. He's right. Go back to the courthouse. Go back.
Hey, do not move by the courthouse. Do not stop now. Do not fucking move. Do not fucking move.
It's got 57 minutes.
Let's go
Right here. No, we're not moving.
Get over here.
Brandy.
Judiciary security.
You can move towards her. Do not make your way to the courthouse.
I'm gonna move towards the courthouse until she comes back over. I gotta get my shit.
Yeah. Come on, Brandy.
Brandy, are you able to make distance from them so we can?
Trying.
Hey, that bozo sitting on the side needs to move. All right, I'm listening. What's going on?
Brian, we want to know what your biggest dreams are and how we can help you achieve them.
What, do you have a bomb? Yes or no?
We told the fuck off or he's gonna get hit if you don't shoot these guys.
Okay. Who's got the bomb and what is it that you're asking for?
We're just asking for one
Fix the one with the blue
dreams
flame,
to
right?
become
Blue
true,
flames up
man.
in the
What
middle.
is someone's
Something you
Oh, I
always
can only see one of
wanted.
them.
People to give a shit. And to try. Yeah.
We can't do that.
I know. I know.
And one of those.
Something else.
Soon though.
Marshals, make sure nobody comes through those double doors, please, because
Okay,
they're just
well,
walking in behind us.
okay, think about this, Brian. Okay, we need something we can do right now for you. Besides anything related
You need
to
to
the bomb.
you need to be a little bit more forthcoming. Look, I'm gonna make this rather clear to both of y'all. All right.
I want like not anything but money, Brian.
I need you to understand something for me. All right. We have an entire courtroom full of individuals in there. A court case going on. I need to make a decision whether I'm about to pull this trigger or not. Give me a reason not to.
Pull the trigger, it's a dead man's switch, man.
Well, right now you're outside of the courthouse and you're moving bombs, right?
Listen, all we want is to make one cop's dream come true. That's all we want.
Give us an
I
answer,
want
Brian.
you. My dream is for you to turn off the bomb and put it on the ground.
I don't think we can do that. Anything not related to the bomb.
I want to not have to pull this trigger right now.
You don't have to do that.
Well, you have a choice. Make some distance. I'm going to make this rather clear.
Tell those judges
You're to turn off the bomb now, or you will be open fire upon.
East side of the parking lot.
Oh, shit, okay.
If you move even an inch, you will be open fire upon.
We're turning it off.
Where are they?
Turn it off.
They're on the parking lot side of the promenade. Go tell them to fucking move. They're on a line of fire.
Yeah. Hold on. I gotta just turn this off.
Hold on,
My phone's not working.
we're cutting the right wire.
Yeah.
Make sure you maintain some distance.
Hold on, we gotta get the manual.
Hold on.
Make sure you have enough distance so you don't get into blast radius, all right? Watch your crossfire. Brandy, tell these other two dumb fucks to leave, please. On your right-hand side.
Where are they?
Whose dream are you talking
Right next to Brandy in the middle. They're the one in the pink and blue standing next
All right, is it off?
Need to get out of here? Yeah, you tell them to fuck off.
Okay, now here's what I'm gonna do. I need you guys to fuck off, all right? And we're gonna get you a normal chase. Normal chase or you die.
Okay. Oh, okay. We're fine.
All right, go and pursue, guys. My priority is getting them the fuck away from the courthouse. Pursuit comes afterwards. So if we can chase them, let's get that chase going. We got a vehicle.
We have units to pursue. It's gonna be a blue and yellow four-door vehicle. We're leaving out on Capitol. Equal it.
All right.
Vehicle is exiting now on Davis, left westbound, Innocence Boulevard.
Yeah.
Sending it westbound, Innocence, holding right for northbound Elgin.
Shit was hello?
Northbound Elgin, passing Legion Square.
Okay.
Yellow and blue, I'm not sure what the make a model is.
Y'all are clear for 120 pits on that.
A-firm slowing at the pink cage, left westbound, Hawick Avenue. Right northbound, Power.